Welcome everyone to our second Be Accurate webinar. I'll just check with our team next time that people can hear us okay.
Yes, yeah, can hear.
Great, thanks Bonnie. Some of you might have already attended our webinars in the past or even hopefully attended our in-person workshop. So this is actually our third Be Accurate workshop on understanding legal right and eligible interest holder consent. We don't allow our AI bots into these webinars at the moment as part of CER policy, so apologies if you did have one you were hoping to have enter and take notes for you, but you'll have to do that yourself. We will also be publishing the presentations from today on our website, so hopefully that'll be a useful resource for you to return back to in the future. So for those of you who don't know me, I'm Jennifer Bradley, and I'm the General Manager of one of our AccuScheme branches, the Soil Emissions Avoidance and Contracts branch. As we begin today's webinar, I'd like to start by acknowledging the traditional owners of the lands on which we are meeting today. For me, I acknowledge the Ngunnawal people as the traditional custodians of the ACT, and I also acknowledge any other families with a connection to the land we're meeting on today. I'd like to acknowledge and respect the continuing culture and contribution of Aboriginal and Torres Strait Islander people to these lands, and like to welcome any Aboriginal and Torres Strait Islander people dialing in today. So there are a couple of reasons we've chosen today's topic. The first one is that we've heard from both participants and assessors that getting your evidence correct for legal right and eligible interest holder consent can be quite tricky, and it is often an area that we do have to send formal requests for information on. And what that does do is it does significantly delay the process and the time it takes for us to register your projects or issue you with credits. The other reason that we decided to focus on these topics today is that they're really critical to AccuScheme eligibility. So in the very unfortunate circumstance where we find out later on that there is a problem for legal right, where perhaps you didn't get your land titles right and you didn't have legal right for all of them, that does in fact mean that your project could be susceptible to revocation and your accus could be relinquished in that instance. So it's really, really important to ensure that your project remains eligible and that you can continue to earn accus for your crediting period, that you maintain legal right and eligible interest holder consent, and that you correctly demonstrate those requirements right from the start. As I said, we'll record this webinar today, in particular the presentations, but your microphones and your camera will be turned off. Given the large number of attendees we're very excited to have, I think we're getting close to 250, so that's probably a new record for us. So we do appreciate the time everyone gives up to listen to us. So I will now hand over to our presenters. We have Bonnie Scott from our Savannah Agriculture and Soil team, and we also have Taylor Mason from the Land and Forest team. Over to you, Bonnie.
Okay, so thanks for the introduction, Jenny. I'm Assistant Manager in the Savannah Agriculture and Soil section. So that does mean my experience has been in the area-based projects, specifically Savannah Fire Management, Soil Carbon and Blue Carbon. So my references will lean to the area-based projects, but the legal rights section is still relevant for our non-area-based projects. And we do have Elliot Curley on our panel, manager of those, administering those methods as well. So just a bit of introduction there. So firstly, I'll talk about legal right, and then I'll go into eligible interest holder consent. So a project proponent for an Australian Carbon Credit Unit or ACCU scheme must have and maintain legal right to carry out the project. It is the project proponent who is responsible for the project in complying with the ACCU scheme legislation. To participate in the ACCU scheme, the project proponent must have and maintain legal right for the life of the project. So firstly, what does legal right mean? Legal right means that the project proponent has two elements. Firstly, the right to carry out the project activities on sites included in the project area, and importantly, the lawful and exclusive right to receive all accus that may be created through project activities. The project proponent, as mentioned, must demonstrate that they can maintain legal right for the life of the project. This usually means 7 years for non-area-based emissions avoidance projects and 25 years for area-based projects. Applicants will need to demonstrate that they have and will maintain legal right throughout the life of the project. So when you're demonstrating it, that will be when an application is submitted to register a project, when an application is submitted to vary a project, and also with project offsets reports. So in my experience, when assessing applications, we do often require additional information to demonstrate legal right. As Jenny mentioned, that's why we're taking the time today to discuss the obligations, explain what it means, and then what evidence we need to be satisfied of it. Because if legal right is lost, we may revoke the project, require relinquishment of ACCUs, and in the case of sequestration projects, may issue a carbon maintenance obligation. So that's why when deciding on running a project, who has a legal right interest needs to be carefully considered. The types of interests we see in Australia often include, but are not limited to, freehold estate, land rights land, leasehold estate, and native title. I will now step through each of these interests and explain why they have or are likely to have a legal right interest in an ACCU project. So firstly, freehold estate. Fee simple is the most common type of freehold estate in Australia. If someone owns a fee simple estate, the person has a form of ownership that is closest to absolute ownership of the land. Freehold estate does include the right to carry out the project activities and the lawful and exclusive right to receive all ACCUs that may be created through project activities. So that means that persons with freehold estate do have a legal right interest in the project. So land rights land. Land rights land are rights afforded to traditional owners under state or territory legislation. These rights must be considered by anybody planning a project on Aboriginal land, referred to in the Carbon Farming Initiative Act as land rights land. Projects planned to be carried out on land rights land must comply with any requirements under the governing legislation. In some cases, Aboriginal land rights are similar to freehold and give landholders the legal right to both carry out the project activities on sites included in the project area and the lawful and exclusive right to receive all ACCUs that may be created through project activities. Skipped one. Leasehold estate. Leasehold estate is a form of land tenure where one party, the leasee or tenant, has the right to occupy and use the land or property for a specific period under a lease agreement with the owner. This right of possession is temporary, unlike freehold ownership, and is defined by the terms of the lease. The leasehold estate can be bought and sold, but the ownership remains with the freeholder. Depending on the terms of the lease, persons with a leasehold estate may have a legal right interest, and that is the right to carry out the project activities and may have the right to lawful and exclusive right to receive all the ACCUs. And then finally, native title. Native title refers to the rights and interests First Nations people have in land and waters based on their traditional laws. Even if these rights haven't fully been recognised by a court, they may still exist. Native title may affect legal right to carry out the project. That is, the right to carry out the project activities and the lawful and exclusive right to receive all ACCUs. And so this will be discussed in more detail by my colleague Taylor following my talk. So yeah, just because there's lots of different components to that one. So far I have explained what legal right under the ACCU scheme means and the different types of legal interests. Next, I will be discussing the evidence requirements to satisfy us that project proponents have the legal right. So to support our assessment of applications, evidence of legal right may include a clear explanation that identifies the persons or entities with legal right. Supporting evidence of this would be land titles, and if leasehold land, the terms of the lease supported by an explanation on how the project activities are allowed. So secondly, where relevant, assessments of whether future acts regime applies, evidence of native title act notification and consultation requirements being satisfied, Indigenous land use agreements or agreements with registered native title bodies corporate. Thirdly, if a project proponent has been given legal right from a third party, applicants should provide a written agreement, such as a commercial contract or signed statement, noting that this can be an excerpt. And for any signed agreements, applicants should provide supporting evidence of authorisation to sign under the Corporations Act 2001. So, for example, ASIC documents are very useful evidence of directors and secretaries of an organisation. Finally, applicants should check the project boundary mapping closely conforms to the correct land titles. So for those who attended the in-person event in Canberra earlier in the year, this was explained by Michelle McDonald, and we do have a recording on our website of those presentations also. So to improve the quality of applications and therefore application processing times, we are working on some tools that applicants could use to demonstrate legal right. So the first tool is a legal right template that covers the two elements of legal right under the ACCU scheme, including the requirement to run activities and earn ACCUs. And secondly, an evidence template that can act as a checklist, so applicants can do their own due diligence. And that would identify who the legal right interests are and the eligible interest holders. If land titles are entered correctly into the application, that all land titles are provided, that the project boundary covers the correct area, and an explanation of any notes and caveats on the land titles that may or even may not be of relevance. We are aiming to circulate these for feedback following the webinar. So that concludes my presentation on legal right, and you should now understand what legal right under the ACCU scheme means, the different type of legal interests, and evidence requirements to satisfy us that project proponents have the legal right. Next up, I will discuss the eligible interest holder consent for area-based projects. I will refer to eligible interest holder consent sometimes as EAH, just to save my voice a little bit. Area-based emissions avoidance and sequestration projects must have the consent of any person or organisation with an eligible interest in the project area. The consent ensures stakeholders are aware of the project and any risks or benefits to them. It's important to make sure that eligible interest holders understand what they are agreeing to. That's because consent can't be withdrawn once a project is registered without condition. We understand sometimes these conversations can be complex. If there are delays in obtaining consents, proponents should contact us before the latest deadline of the end of the first reporting period. If consents cannot be provided, the project will need to be varied or revoked. So to manage this risk, it is important project proponents start engagement as early as possible, ideally well before the project registration application is submitted. Sometimes we may ask for evidence of this engagement so that we have confidence that the project proponents have capacity to gain consent and therefore the skills and experience to undertake the project. So, who is a person with an eligible interest in the ACCU scheme project? An eligible interest holder is any person or organisation that has an interest in the land a project will run on. This might include landholders, banks or mortgages, state and territory crown land ministers, registered native title bodies corporate, or other eligible interests such as easements. So transmission line easements do have an interest in the land, and that comes a lot, especially in the soil carbon space. So a listing of eligible interest holders is in sections 43 to 45A of the Carbon Credits Carbon Farming Initiative Act 2011. There may be more than one eligible interest holder in a project area. It's also important to note that parties that have granted legal right to conduct the project may also need to provide their consent as an eligible interest holder. And so the next natural question is, when are consents required? Consents are required firstly when registering a new project or before the end of the first reporting period. If signed consent forms from each eligible interest holder cannot be provided with the application to register a project, it can be registered with the condition of obtaining these consents. This is often referred to as conditional registration. If a project is conditionally registered and the project can't receive ACCUs, all outstanding consents should be provided before the end of the project's first reporting period. Once all consents have been provided, proponents can apply to have the condition removed and may then report to claim ACCUs. And secondly, when adding new area to an existing project. Before adding new area to an existing project proponents must obtain written consents from all eligible interest holders of the new area and provide this with the application to vary the project. And finally, when moving from an emissions avoidance only area-based project to an emissions avoidance and sequestration method. For example, if existing Savannah Fire Management emissions avoidance only projects choose to move to the existing 2018 sequestration project or the new Savannah Fire Management method in draft with DQ, consents will need to be provided at that point in time also. So far, I have explained what eligible interest holder consent under the ACCU scheme means, who are the possible eligible interest holders, when consent is required. And next I'll be discussing the evidence requirements to satisfy us that consent has been obtained, and also other consultation requirements that may arise for some projects. The evidence requirements for eligible interest holder consent are, firstly, consent must be provided in the approved consent form on our website. I note that we are working on updates to the existing forms, and these will replace the ones on our website. Every eligible interest holder must sign their own separate form. Please check that the details are entered correctly, such as the proponent organisations identified, or the project details, including land titles, are also in there, and the correct details of the persons with the eligible interest. So where relevant, consent can be set out in an Indigenous land use agreement that's made and registered under the Native Title Act 1993. Also accompanying the form, applicants should provide evidence that the person signing the form is authorised to do so on behalf of the person with the eligible interest. Following these evidence requirements supports our ability to process applications in a timely manner. And positive relationships with persons with an eligible interest is important throughout the life of the project. There may be some occasions where consultation is required after the project is registered unconditionally. So, for example, if we receive an application to vary proponent, we will engage registered native title bodies corporate that fall within the project area. This is because when making a decision on a change to the project proponent on an existing project, we must have regard to any impact of the decision for native title holders of all or part of the project area. Before making a decision, we must take all reasonable steps to notify the registered native title bodies corporate of the application to change proponent and invite them to make a submission within at least 28 days after the notice is issued. And we may consider submissions submitted after the 28 days if more time or resourcing is required. So this may delay the application processing times. I will now hand over to my colleague Taylor, who will talk in more detail to native title consent. Thank you.
Hi everyone, my name is Taylor. I know some of you were expecting Rhiannon to step in, but she's had to step out, so I'm stepping in her place. I work in the Land and Forest team with her as well, and I'm here to talk to you guys about native title consent. So what is native title consent? Native title is the recognition under the Australian law that Aboriginal and Torres Strait Islander people have rights and interests to land and waters according to their traditional laws and customs. It was formally recognised following the Mabo decision in 1992 and is protected under the Native Title Act 1993. The federal court makes native title determinations to decide whether native title exists over a specific area of land or water. If it does, whether it's exclusive possession, where others are excluded, or non-exclusive possession, where rights are shared, who holds the native title, and the nature and extent of those rights and interests. An area is considered native title land if it's listed on the Native Title Register as having native title rights considered over it. And you can just Google that. There is an entire website available that shows you on a map of Australia where each of the native titles are held. So when registering a project on land subject to native title, it is important to consider who will take on the role of the project proponent, as this party will be legally responsible for the project and begin genuine and early engagement with native title holders to build a shared understanding of the project's conditions and requirements. This approach helps ensure respectful collaboration and compliance with legal and cultural obligations. If native title holders have exclusive possession, they have the right to possess and occupy the land to the exclusion of all others. This means that they can act as the project proponent with the legal authority to carry out the project and receive Australian Carbon Credit Units, or ACCUs. However, if a third party wants to act as the project proponent, the native title body corporate must first transfer the legal right to that party and also provide eligible interest holder consent for the project to still proceed. Native title rights and interests over an area are clearly outlined in the native title determination. These rights can include the ability to live on the land, hunt, fish, gather food, perform traditional ceremonies, and maintain sacred sites. In this context, the native title body corporate is considered an eligible interest holder. That means that their consent must be obtained before the end of the project's first reporting period to ensure compliance with the ACCU scheme, as Bonnie just stated. So what is a claimant? A claimant is an Aboriginal or Torres Strait Islander person or a group who has lodged a native title claim with the federal court under the Native Title Act, and that claim has been accepted for registration by the Native Title Tribunal. This claim asserts that they hold native title rights and interests over a specific area of land or waters based on their traditional laws and customs. Claimants may have procedural rights under the Native Title Act in relation to acts that may affect native title. These claimants may also hold rights that have not yet been determined or recognised by a court. This is important as under the Native Title Act, registered native title claimants may have procedural rights in relation to certain activities that may affect native title. These can include the right to be notified of proposed activities, the right to comment or object, and in some cases, the right to negotiate. These rights apply even before a native title claim is determined, provided the claim is registered. For further information, the Native Title Tribunal maintains a register of all registered native title claimant applications, which can be found quite easily. So what is free, prior and informed consent? FPIC for short, is a principle that protects the rights of Indigenous people to decide whether or not to consent to a project or activity that could affect their land, territories or cultural rights. It's built on three key elements. Free, consent must be given voluntarily without pressure, coercion or manipulation. Prior, the process must begin before any project activities start, giving communities time to consider and participate in decision-making. And informed, Indigenous peoples must receive clear, accessible and complete information about the project, including its potential benefits and risks. It is strongly encouraged through industry standards and best practice guidelines, especially for projects involving Indigenous land or interests. Respecting FPIC is essential to ensuring that First Nations eligible interest holders are treated fairly and that projects are developed in a way that is equitable, ethical and just. That is why it is important for a proponent to engage early and seek consent before moving forward with any projects that may affect Indigenous communities or their land. So following all of that, what does best practice look like? When projects are being conducted on native title land, the CER will ask proponents to provide information at registration to demonstrate how they have applied best practice and considered the principle of free and prior informed consent. Things that you could provide to evidence free, prior and informed consent is documented records of meetings, consultations, correspondence with First Nations eligible interest holder consents, evidence that information was shared in culturally appropriate formats and languages, and clear timelines showing that consent was sought prior to project approval or any activities. Not engaging in free, prior and informed consent can have significant consequences impacting your ability to report and receive ACCUs, as well as impact the continuation of the project. It is important that when an individual is signing on behalf of a registered native title body corporate, RNTBC for short, that they provide evidence that they have the authority to do so. These individuals are typically granted, directors, company secretaries, or appointed agents who are granted the authority through the RNTBC's rules or a board. In 2022, the independent review of the Australian Carbon Credit Units recommended that the Carbon Farming Initiative Act be amended to remove the option to conditionally register projects on native title land before obtaining consent. This recommendation was made to better align the scheme with the principles of free, prior, and informed consent. Following this, in February 2025, the Assistant Minister for Climate Change and Energy announced that the government would act on this recommendation by introducing a requirement for upfront consent from native title holders before a project can be registered. Following all of that, in 2023, the Climate Change Authority also recommended that project proponents under the ACCU scheme should be required to apply best practice principles to seek free, prior, and informed consent from native title holders and claimants. The Australian government agreed in principle with this recommendation and acknowledged the importance of strengthening Indigenous engagement in carbon projects. To support this, legislative amendments are currently under consideration. These changes will be progressed by the department in line with government priorities and broader reforms to improve the integrity and inclusiveness of the ACCU scheme. So that was it on native title consent. I'd just like to provide a quick update on some guidance that's being provided. So the CER is publishing new guidance on what happens after your project's crediting period ends. So for sequestration projects, permanence obligations continue for either 25 or 100 years, depending on the project. And even after the crediting period finishes, you're still required to submit a report, or at least once every 5 years, right through to the end of your permanence period.
So hopefully you all found that useful. Thanks very much to our presenters and to our panelists. And thanks very much to everyone who dialed in. We know it's hard to find that extra hour and a half. So we do appreciate the fact that we know this is important for all of us and we all want projects to be registered and be successful. So thanks everyone. We'll close there.